Good afternoon. Good afternoon, everyone. Good afternoon and welcome. I'm Dean Reuter, General Counsel, Vice President, and Director of Practice Groups at the Federalist Society. Thank you all for being here today. Welcome to our program. I just want to give you some idea of how the program is going to unfold so you know what to expect. I'm going to first introduce our guest speaker, George Will. He's going to make about 15 minutes of remarks, and we'll ask you to hold your questions for him, but then I'll introduce Adam Liptak, who will introduce the panel. We'll have that panel discussion. George Will's going to stick around for that, and then ultimately we'll open the floor to questions. So, to the business, George Will received his undergraduate degree in politics, philosophy, and economics from Trinity College in Connecticut and Magdalen College in Oxford, and his MA and PhD in politics from Princeton University. After earning his doctorate, he worked in the U.S. Senate. He's taught courses on political philosophy at numerous universities throughout the country. He was an editor for National Review from 1972 to 1979. In 1977 there, winning the Pulitzer Prize for Distinguished Commentary. Mr. Will has served as a commentator or contributor for numerous national media outlets, including ABC, Fox News, and most recently MSNBC and NBC News. He's the author of the forthcoming book, The Conservative Sensibility, due out in June of 2019. I have no idea what that's about, but and that is from Hachette Books. Three decades ago, the Wall Street Journal described George Will as, quote, perhaps the most powerful journalist in America, close quote, and I don't think his power or influence has decreased since then. So please join me in welcoming George Will.
Thank you. Thank you very much. What is it about Love Field? In contrast to its pleasant name, this wee patch of Texas seems to attract trouble. There on November 22nd, 1963, Air Force One landed after a short flight from Fort Worth, and from Love Field, President Kennedy drove to Dealey Plaza past the Texas School Book Depository. A few hours later at Love Field, Lyndon Johnson was sworn in as president. The Dallas-Fort Worth Airport did not yet exist. The building of DFW Airport pulled Love Field into national policy controversies that led to this case. The case seems to some people, but not to others, to implicate the Constitution's takings clause, which says that private property shall not be taken for public use without just compensation. The history of the public use stipulation has been rich in recent controversies arising from government uses of the power of eminent domain. The Constitution's authors did not scatter adjectives carelessly, and until relatively recently, the straightforward understanding of the phrase public use was that it meant use for things, roads, bridges, courthouses, and so on, used by the general public. However, this circumscription of the eminent domain power has been drastically weakened. A 1954 case involved what was then called urban renewal in the southwest quadrant of the District of Columbia, where conditions were appalling and dangerous. Most dwellings had no baths, indoor toilets, or central heating. The tuberculosis rate was high. The court held that taking property for public use can mean for the public purpose of combating blight that harms the larger community. In 1981, Michigan's Supreme Court allowed the bulldozing of Detroit's Poletown neighborhood, more than 1,000 residences, 600 businesses, and many churches, so the property could be conveyed to a more lucrative revenue source, General Motors. Early in this century, Connecticut's Supreme Court, relying on the Kelo case, on the Michigan decision, held that an entire neighborhood could be razed to make way for a private commercial development that would constitute a public purpose by filling the public purse of New London's government. The U.S. Supreme Court divided 5-4 in agreeing with the Connecticut court. The Love Field case involves a different but related threat to property rights. This one arising from a policy of domestic protectionism, which, like protectionism generally, always and everywhere either begins as or soon breeds crony capitalism. In the late 1970s, airline deregulation unleashed competition, which was annoying to the new Dallas-Fort Worth airport. It feared that a pipsqueak airline named Southwest, operating out of Love Field, and hitherto restricted to interstate flights, would take flight, and that Southwest would siphon off enough DFW traffic to slow the flow of revenues needed to service DFW's bonds. Congress, obedient to Jim Wright, a Texan who was Speaker of the House, stipulated by statute that flights out of Love Field could be made only by planes with 56 or fewer seats and could only fly to 4 contiguous states. When Southwest mounted a powerful protest against these restrictions, 5 parties to the dispute, Southwest Airlines, Dallas-based American Airline, the cities of Dallas and Fort Worth, and the DFW Airport Authority, agreed to a compromise at the expense of a 6th party who was not a participant in the negotiations. The 6th party was the Love Terminal Partners, owners of 12 Love Field gates that were demolished as part of the 5-party agreement to limit competition. The Love Terminal Partners had been paying tens of millions of dollars in taxes and other carrying costs, perhaps wagering, or hoping at least, that deregulation and the consequent explosive growth of air travel would repay their investment. Seeking compensation for its taken property, its gates, the Love Terminal Partners won a $133.5 million judgment in federal claims court. But a federal circuit judge overturned this judgment, arguing that the Love Terminal Partners were owed nothing because the partner could not prove that their property was worth anything at the time it was destroyed, which raises 2 questions. If the gates were without value, why were the 5 parties to the agreement so eager to destroy them? And if the gates were valueless, why did the partners pay so much to maintain them? Clearly, a number of persons ascribed value to the gates that the Federal Circuit judge considered valueless. Now, one should not casually ascribe motives to judicial reasoning. However, the circuit court's conclusion looks like an attempt to use the Love Field case to increase the difficulty of contesting regulatory takings generally. In a moment, a panel will discuss the details of this case and its portents. Before this, however, it is pertinent to note that the case comes to the Supreme Court at an interesting moment in the nation's political and intellectual history. I refer not just or even primarily to the fact that suddenly a significant number of Americans are expressing warm feelings about socialism, which they think deserves one more chance to not make a mess of things. Rather, I refer to the revival of a theory that serves to derogate property rights. Progressives increasingly argue as follows: because everyone is socially situated, we should minimize ascribing achievements, such as the acquisition of property and wealth, to individuals. Instead, we should think of everyone's achievements as more or less society's achievements. The progressive argument goes like this: because government is the organizer of society, and because society is the shaper of the individual, government, which is the enabler of striving, is the proper arbiter of the equitable distribution and use of the social product, which is wealth. One progressive theorist, Edwin C. Hettinger, has attacked the very idea of intellectual property rights by attacking the idea of individual achievement. He says, and I quote, "Invention, writing, and thought in general do not operate in a vacuum. Intellectual creation is not creation ex nihilo. Given this vital dependence of a person's thoughts on the ideas of those who came before her, intellectual products are fundamentally social products. Thus, even if one assumes that the value of these products is entirely the result of human labor, this value is not entirely attributable to any particular laborer or small group of laborers," end quote. Something quite sinister is being done here. The banal fact that no person lives or thinks or works in a vacuum, the fact that everyone is situated in society, becomes the basis for asserting a vital dependence of the individual on society. This, in turn, is said to justify declaring that there should be no individual property right to intellectual work. The products of such work are, because of the individual's immersion in society, properly regarded as inherently socialized. By this argument, individualism is attenuated to the point of disappearance, and society can claim ownership to whatever portion it feels entitled to of what individuals produce. In the Soviet Union, of course, society claimed ownership of the individual, period. People wishing to immigrate were denied permission on the ground that they would be taking away education that had been provided by the state. Because the education could not be left behind, the individual could not be allowed to disassociate from society. In effect, the individual could not be distinguished from society. This is where the attack on individualism leads. It begins with the assertion that democratic theory, quote, exaggerates the part played by human choice. So wrote Professor Woodrow Wilson in 1889. One can sympathize with the exasperation that caused Margaret Thatcher to exclaim, "There is no such thing as society." Well, there is such a thing, of course, but its existence should not be seen as an excuse for dissolving the individual into a broth of dependencies or regarding the idea of individual achievement as sociologically unsophisticated, indeed an oxymoron. This dissolution of the individual and this disparagement of the idea of individual achievement remains part of the pulse of progressivism. During the 2012 presidential election, there occurred one of those remarkably rare moments when campaign rhetoric actually clarified a large issue. It happened when Barack Obama, speaking without a written text in Roanoke, Virginia, spoke from his heart and revealed his mind. He said, and I quote, "Look, if you've been successful, you didn't get there on your own. You didn't get there on your own. I'm always struck by people who think, well, it must be because I was just so smart. There are a lot of smart people out there. It must be because I worked harder than everybody else. Let me tell you something. There are a whole bunch of hardworking people out there. If you were successful, somebody along the line gave you some help. There was a great teacher somewhere in your life. Somebody helped to create this unbelievable American system that we have that allowed you to thrive. Somebody invested in roads and bridges. If you've got a business, you didn't build that. Somebody else made that happen. The internet didn't get invented on its own. Government research created the internet so that all the companies could make money off the internet." Close quote. 14 of those words, of course. If you've got a business, you didn't build that, somebody else made that happen. Those 14 words ignited a heated debate, and Obama aides insisted that their meaning was distorted by taking them out of context. But Obama was merely reprising something said a few months earlier by Elizabeth Warren, a former member of his administration who then was a Senate candidate in Massachusetts. Warren said, and I quote, "There is nobody in this country who got rich on his own. Nobody. You built a factory out there, good for you. But I want to be clear. You moved your goods to market on the roads the rest of us paid for. You hired workers the rest of us paid to educate. You were safe in your factory because of police forces and fire forces that the rest of us paid for. You built a factory and it turned into something terrific or a great idea, God bless. Keep a big hunk of it. But part of the underlying social contract is you take a hunk of that and pay forward for the next kid who comes along." So said Elizabeth Warren, who was then a member of Harvard's faculty. Of course, Mr. Obama, with his statement, and she with hers, were bayoneting a series of straw men. Warren, like Obama, was refuting propositions that no one asserts. Everyone knows that all striving occurs in a social context, and all attainments are, to some extent, enabled and conditioned by contexts that are shaped by government. But what made Warren's riff interesting and Obama's echo of it important is that both spoke in order to advance the progressive project of diluting the concept of individualism and with it the concept of property rights. Such dilution is a prerequisite for advancement of a collectivist political agenda. The more that individualism can be portrayed as a conceptual mistake, as a chimera, and the more that any individual's achievements can be considered as derivative from society, the less such achievements warrant respect, and the more society is entitled to conscript, that is, to socialize, whatever portion of the individual's wealth that society considers its fair share. Progressivism preaches that society may, as an optional act of political grace, allow the individual to keep the remainder of what society thinks is misleadingly called the individual's possessions. Note, however, that society necessarily means society's collective expression, the government. Note also that government will not be a disinterested judge of what its proper share of other people's wealth is. The collectivist agenda is antithetical to America's premise, which is this: government, including such public goods as roads, schools, and police, is instituted to facilitate individual striving, which is also known as the pursuit of happiness. Of course, individuals often collaborate, sometimes through government, to make collective choices that facilitate individual striving. This does not, however, compel the conclusion that the collectivity is entitled to take as much of the results of striving as it judges itself entitled to. Warren's and Obama's statements were footnotes to progressivism's comprehensive disparagement of individualism and individual autonomy. Warren and Obama asserted something unremarkable, that the individual depends on cooperative behavior by others. Warren is a former law professor, Obama is a former law lecturer. They each are evidence for two axioms. One is that ideas have consequences. The other is that what happens on campuses does not stay on campuses. To the extent that the phrase individual initiative comes to be regarded as an oxymoron, to that extent the rights to property that individuals acquire through initiative will become devalued, attenuated, even chimerical. This is a facet of the intellectual context in which the Love Terminal case arrives at the Supreme Court. Ideas have consequences. The antidote to a bad idea, such as the progressive idea that property is necessarily socialized by the very context of its creation, needs a better idea. A better idea deserves, so to speak, its day in court. A better idea will be involved when the Love Terminal case has its day in court. The administrative state has a metabolic urge to expand the subordination of society to its regulatory impulses. The principal obstacle to the administrative state's imperialism is a robust regime of protection for property rights. This, I suggest, is part of at least the background of what is ultimately at stake in the case we have gathered here to discuss. Thank you.
All right, let's proceed with our panel. Thank you so much, Mr. Bull. It's great to have you here with us. Now to introduce our moderator, Adam Liptak. I'm very proud to have Mr. Liptak here as our moderator, always welcome at the Federalist Society, and when I gave him a call, he almost always says yes, so I appreciate him being here today. He is a graduate cum laude from Yale in 1984, where he was editor of the Yale Daily News. After a brief stint working for the New York Times in various capacities, I think as in the mailroom, as among other things, he returned to Yale for law school. During law school, he worked as a clerk in the New York Times Company's legal department, and then graduated with a law degree in 1988. He spent 4 years as a litigation associate focusing on First Amendment issues, and then he returned to the New York Times legal department, where he advised the company on defamation and privacy matters. In 2002, he joined the company's news team and has since written numerous pieces on topics such as judicial ethics and criminal justice. He's recognized as a Pulitzer Prize finalist in 2009 for his series American Exception, on how America's United States legal system is different from those of other developed nations. He's still currently with the New York Times, he is currently the New York Times Supreme Court correspondent, and we're very pleased to have him with us. Please join me in welcoming Adam Liptak, and let's call the panel forward if we could.
Well, it's always a great pleasure to read George Will, and an even greater pleasure to listen to him. That was such a nice, closely argued general statement, and also set up the case we're going to talk about today. I had thought maybe I would need to set the table, but it turns out I didn't. George's general introduction of what's going on in the case is just right. I would add only that there's a petition for certiorari, a petition asking for Supreme Court review pending, written by Paul Clement, characteristically excellent petition. We don't have the government's response yet. It's due May 15th, but I would think the court will be quite interested in this case. So let me introduce the panel, and there's so many ways to think about this case. I have a feeling we're going to get quite a good, broad, robust discussion. On my immediate left is George Priest, the Edward J. Phelps Professor of Law and Economics at Yale Law School, who is an internationally recognized expert whose research has focused over the past 2 decades on antitrust, the operation of private and public insurance, and the role of the legal system in promoting economic growth. George was also a professor of mine, one who managed to make antitrust law lively and accessible to an English major. He was also quite funny and reasonably conservative. Those are qualities each of which made him a unicorn at Yale Law School. Elizabeth Papez is a partner at Gibson Dunn, where her practice focuses on class actions, other complex commercial litigation, and government investigations and appeals. She served as a law clerk to Justice Clarence Thomas and in the Justice Department's Office of Legal Counsel. And she's filed an amicus brief. This case has attracted quite a large and interesting group of amicus briefs. She filed one on behalf of JetBlue in the case that will serve as the springboard for our discussion. And then finally, J. Peter Byrne is the John Hampton Baumgartner Jr. Professor of Real Property Law at Georgetown, and its faculty director of its Environmental Law and Policy Program and of its Climate Resource Center. He served as a law clerk to Justice Lewis Powell. George, tell us what the right way to think about this love terminal case is.
Thanks, Adam. And I remain a unicorn at Yale Law School. Well, I teach at a law school, as Adam has said. I believe in the rule of law. I believe that the legal system on the whole, along with the market, or let's say complementary to the market, works to the benefit of society. But this case turns all that on its head. It really does. It's almost fantastical, this case. Now, George Will has given a very good introduction of it. I'm going to go over some of this just briefly enough to show how crazy I think, and crazy is not quite right. I'll try and give some explanations of it, but how peculiar and really fantastical is probably the right word this case is. Now, in this case, the private company, the Love Field Partners, believed that the value of air transport from Love Field was going to increase, as George has said. And so it entered leases with the city of Dallas, contracts with the city of Dallas for to provide commercial air service, not to provide it, but to provide the grounds for commercial air service at Love Field. Subsequently, in the year 2000, it built a terminal, the Lemon Avenue Terminal, investing $17 million to build that terminal, adding 16 new gates or 12 new gates at the outset to achieve that objective. Now, there was lots of regulatory turmoil in subsequent years about reducing the limitations on air travel that George Will has described out of Love Field. And in 2006, Congress recommended that the cities of Dallas and Fort Worth get together and propose a resolution, just a recommendation from Congress. The cities decided to do this, but not just on their own, which I think is quite significant, but by bringing in the Dallas-Fort Worth Airport Authority, which is a subsidiary agency, and two private parties, totally private parties, American Airlines and Southwest Airlines, both competitors in different ways of the Love Field partners. Now, this group got together, and as George has described, reached what's been called the five-party agreement, which was later enacted by Congress in the Wright Amendment Reform Act, WARA. Now, this enactment simply wiped out entirely the value of the Love Field partners' leases, and authorized the city of Dallas, which had entered these lease agreements with the Love Field partners, authorized the city of Dallas to demolish the terminal, which the Love Field partners had built. As such, the Love Field partners are left with zero. The Federal Circuit held that these actions did not constitute a taking under the Fifth Amendment. Now, how could this be true? I mean, just think about this in terms of, you don't have to be a lawyer to think about this. How could this possibly be true? Again, it's fantastical to imagine. As a result of WARA, which derived from the five-party agreement, the leases that the Love Field partners had entered with Dallas were rendered valueless. So Dallas receives these payments for leases for all these years, enters a contract with the Love Field partners, and then acts in a way or joins this group to make the leases valueless. And then Dallas demolished their terminal. Again, it was brand new. It was a state-of-the-art terminal. The city simply demolished it. Now, how could this not be a taking requiring compensation? Just in terms of common sense, how can it not be? Now, the Federal Circuit argued that it might have been a taking, but the leases and the terminal were not yielding a positive cash flow prior to the enactment of WARA, so there was no loss. But this is a ridiculous point, really, by the Federal Circuit. Indeed, if a student at Yale Law School or at any law school for that matter, were to write something like this on an exam, he or she would be in very deep trouble. It's well established in economics, so well as to be basically a truism, that the current market value of property equals the expectation of future earnings, not past cash flow. Past cash flow really has nothing to do with it. It's the expectation of future earnings. And again, think about this. The Pilgrims and subsequent settlers coming to America arrived at a land that had no past cash flow. Zero past cash flow. By this definition, America was worthless. Again, it's hard to imagine this principle. And of course, as George Will has pointed out, it defies economic reality. The Love Field partners are repeatedly described in the Court of Claims opinion as savvy investors. Indeed, the director of the endowment at Yale, who is regarded as the most savvy of educational endowment directors of the world, he's based on his past performance over the last 2 or 3 decades, according to the Court of Claims, attended the due diligence review by the Love Field partners and invested in it. Now that's savvy. This guy is savvy. Swinson is savvy. Now, I haven't talked with him about this case, and my point of view has nothing to do with the Yale endowment. But you've got a group of savvy investors who are making serious investments, which simply belie, and George Will made this point too, simply belie the claim that the leases and the terminal were valueless. Now, the second proposition, again, almost hard to believe, by the Federal Circuit, is that the city of Dallas, though a signatory of the leases with the Love Field partners, could demolish the terminal, in which, again, the Love Field partners had invested $17 million and later another $6.5 million, because after the enactment of WARA, wiping out the value of the air carrier leases which Dallas had entered with them, the Love Field partners quit paying the lease payments because, again, the leases were valueless thanks to the five-party agreement in WARA. So they quit paying the leases and they were evicted. And once they were evicted, Dallas, according to the Federal Circuit, Dallas could demolish their terminal. But this too is fantastical. The city of Dallas, which had marketed these air transport leases to the Love Field partners, and which had received lease payments and were continuing to receive lease payments from the Love Field partners, enters an agreement with a bunch of competitors of the Love Field partners, later codified by Congress, wiping out the value of the leases. And then when the Love Field partners refused to continue paying for what Dallas and these other private parties had made valueless, they're evicted. And so Dallas tears down, demolishes entirely their terminal. Now, the Federal Circuit held, because all of this was effectuated through the normal legal process of eviction, it did not constitute a taking. Now, again, this too is unbelievable. Imagine a landlord enters a long-term lease for land. The tenant builds some building on it or a house, something like that might be in competition with other interests of the landlord and others. The landlord makes the house uninhabitable. And when it becomes uninhabitable and the tenants refuse to continue paying, evicts them and tears down the competing house. Now, there's no remedy for this. Again, it's just hard to imagine our legal system how this string of logic could be put together. So I have to say, you asked me to explain it. I don't know how I can explain it. But I think this case really shakes my belief in the utility of the legal system, and that the legal system is working to enhance the benefit of society. But as George Will has pointed out, the case isn't over yet. And hopefully someone will bring some reason to this process. Thank you.
Elizabeth, I suspect you're not going to disagree with a whole lot of what you've heard, but why don't you amplify and elaborate on it?
I'd be happy. It's great to be here. Thanks. As Adam noted, full disclosure, we did file the brief for JetBlue. That paper speaks for itself. I'm not here on behalf of the company, but rather in my capacity as a practitioner who, along with my colleagues, sees the issues in this case, percolate up for a lot of clients and a lot of different industries in a very practical and I think stark way that I'd like to talk about for a couple of minutes, because I think it really puts maybe even a finer point on some of the observations George has made about the Federal Circuit test. And, one of the reasons this is so interesting, and this is, by the way, the second brief in a takings case we filed this term. The other was just in the, it was the Leon versus Maui case the court declined in December. But these issues are percolating around of great importance to a lot of different stakeholders. And this one, I think, is particularly important because if the court does not take review, the Federal Circuit's decision is the law insofar as redress against the U.S. government for invasions of property rights, right? The Tucker Act and decisions like Apfel say Federal Circuit is where you go. So this test is troubling. I want to pick up on the practical implications. Obviously, it's not just going back to, people coming ashore in the U.S. You drive around your neighborhood, right? We've all seen situations where there's a vacant lot and a developer is going to be paying taxes on that and permitting fees and hiring all sorts of people and contractors and subs to build a house, right? And with the aim of selling it. And under the Federal Circuit's test, literally, that house, the government could take that property, altogether destroy it, take it away, render it completely valueless to the owner, and say you don't get a dime. And the reason is in black and white in the opinion. This is a quote. Here, no regulatory taking took place because the petitioners didn't show, and this is the Federal Circuit's words, that revenue exceeded carrying costs before the adverse government action. right? Again, that's never been the test. You could imagine any number of situations in the real world, right? The JetBlue brief talks about the airline industry. The Airline Industry Council has said at our airports, in order to enable development, because the government doesn't have enough money, we need private investment, the return period is years. The JetBlue brief cites SEC filings, the market, to the point of sophisticated investors. This is not an underperforming investment. It is a perfectly performing investment. People invest for the long haul. They put capital into projects, and they say it's going to be a while before we're cash flow positive. The idea that the government could take all that investment away without compensation is not only a problem, it's going to deter that kind of investment going forward or make it much more expensive to do, and that is a real problem, not just for, an airport or a housing project, but also for society. And to George's, I think, opening point, the notion that these private investment interests are somehow antagonistic with societal interests is just wrong. I mean, in all of the briefs, the JetBlue brief, what we filed in December, there's study after study. The Bureau of Economic Statistics says this: for every dollar. First of all, let me start with the staggering fact that in 2017, for example, McKinsey tells us $70 billion were invested in North American real estate. And then you look at what does that do? For every dollar, they say that generally creates $1.56 in community jobs and in economic activity. For every job, one job that's created on the real estate development project, it results in more than one job in the community in some other aspect. So the idea that real estate development or the cost of these projects is somehow divorced from community is wrong. If we expect private entities to invest for the long haul, in particular, in things like urban redevelopment, parks, community areas, housing projects that will enable people to live and work in places that are going to be more economically prosperous, everything that we're designed and think is a good thing for society, it starts here. Except the Federal Circuit's test has pulled it back in black and white. And what's so astounding about it to me is that they don't cite a single case for this, cash flow test for economic value, which they literally say in the opinion defines economic value for takings purposes. That's contrary to over 100 years of case law that says, as George indicated, it's fair market value that you look at, including expectation interest. But even if you take the narrow view that the court did here and you say, let's assume that all we can look at, forget your expectations under what the statute did, just in the moment before the adverse government action, before the '06 legislation, did you have value? Anyone who thinks of the example in your neighborhood of a vacant lot that's being developed, right, where it's not cash flow positive at that moment, you know what else the Federal Circuit said? There was evidence, uncontroverted, that they didn't overturn from the Court of Claims that said, A, yes, there was interest in this, and B, we were in discussions with airlines before the legislation. Pinnacle was talking about a $100 million lease. JetBlue was interested in the terminal space. The Federal Circuit swept that away with half a sentence. They said, but you hadn't received an actual offer yet. That's like saying the house that's being developed in your neighborhood, they've spent all this money building the house, it's on the market, they're in discussions with a buyer, but the government can come take it away for nothing because they haven't received an actual offer yet. That makes no sense. It's a real problem. And I think some of the statistics in the briefs actually go directly to the point that the practical impact could be quite significant. So hopefully this is not a case where the court will make the perfect the enemy of the good in looking for a case to take this up.
Thank you. Peter, I'm hoping maybe you will have some pushback against some of what you've heard.
Well, that's why I'm here. And I do very much appreciate being asked to come, and I have to say I so appreciate the way the Federal Society always provides a range of views for these meetings. It clarifies what's at stake, and it's always treated with great courtesy, and I appreciate that. So imagine that you purchase a security for $1 million, and if the Fed within a certain period of time raises interest rates by a certain amount, that security is going to be worth $5 million. But if they lower interest rates, the security will be worth zero. How is this case different from that? Well, I'll say in a minute why it's different, but the way it's similar is that the Lemon terminal would have no value unless the Wright Amendment was changed in a way that allowed the Lemon terminal to have access to have enough leeway to be able to make a deal with an airline. And that didn't happen. The legislation embodied a agreement worked out as was described that essentially limited the number of slots as a way to accommodate Dallas-Fort Worth Airport while allowing them to fly wherever they wanted to. And the parties agreed among themselves that they would only use the main terminal, which the airlines that were participating in the agreement did so. So that the lease would only have value if the Lemon Terminal could access airplanes, which they were unable to do in the period before the legislation was passed. That's where the statements come in about the absence of cash flow and the fact that they were just sitting on something that was not going anywhere unless the legislation allowed them to go forward. So in that way, I think it's similar. Well, it's different in the way that what occurred in the five-party agreement was not quite as pristine as what we think goes on in the Fed Open Market Committee in terms of the way they set interest rates. This was some combination of desire to protect Dallas-Fort Worth Airport and some bare-knuckle stuff that happens in Texas over ways to make money. So I can understand why the petitioners in this case feel like they were screwed. I don't know why they weren't involved in the negotiation. I don't know why they couldn't bargain for some piece of the pie, but they didn't. And they may well feel that they were treated unfairly by the five parties and ultimately by Congress even. But was there a taking? Was there a taking? Well, as Elizabeth said, in fact, there was no, or I guess George, there was no actual exercise of eminent domain. The investors in the terminal decided that paying the rent wasn't worth it based upon what they could get in a condemnation proceeding. The federal legislation said that Dallas was to acquire and demolish the Lemon Terminal and indicated that they could do so essentially by either negotiation or by condemnation. When the investors decided not to pay rent, then Dallas was able to take it without engaging in condemnation. So there was no actual condemnation. So we have to step back. Did the actions of Congress effectuate a taking? Congress said they didn't want any federal money to be spent in terms of acquiring the rights to the Lemon Terminal. What I think that Judge Dyke wrote for the Federal Circuit was based, and I think some of the language he used, it was unfortunate. And I certainly agree with the idea that you establish fair market value by the expectation of future earnings. But here, the expectation of future earnings depended entirely on getting favorable legislation from Congress. And for reasons that have to do with the rough and tumble of politics, the investors didn't get that. So what Judge Dyke said, I think, was that whatever value this lease had was entirely dependent upon a positive action in their behalf by Congress, and that there are no regulatory takings cases that can be pointed to in which a property owner was able to prevail on facts like that. The paradigm case is one where the investor purchases and invests under a particular regulatory regime. But that regime becomes, after they purchase and invest, that regime becomes more onerous for the individual investor. Those are the circumstances in which the unanticipated losses attributable to regulation can give rise to a legitimate regulatory takings case. In this case, the risks to these investors were well understood. They understood that by acquiring this lease and by building this terminal, they were only going to make money if Congress acted in a way that was beneficial to them. And what Judge Dyke said, I think, was that that is not the basis for a legitimate regulatory takings case. The language about the lack of value, which I think he did overstate, was tied to the fact that the value was dependent on favorable federal legislation. We don't have any regulatory takings cases like that, and perhaps we shouldn't. Maybe I'll, what I think we had here was an investment that was involved with high risk and high return by investors that could absorb that degree of risk in hopes of a high return, and it didn't happen. And one might well object to the way in which this sausage was made. But that's not a takings issue. That may be a substantive due process issue. It might have been an antitrust issue, but it's not a regulatory takings issue. So I'll stop there and be happy to talk more.
Great, thanks. I have a couple of immediate questions, and I'm sure there's going to be some response from my left. But I wonder, George, having heard some of this, whether you have thoughts before we launch into the more general discussion.
Only two. If there's any place in America that they should understand speculative investments, it's Texas, where, I mean, before in that little hillock outside Beaumont, Spindletop came in, there were lots of dry holes drilled in the expectation of future earnings. Now, in this case, the expectation of future earnings depended upon Congress, and that's, of course, a wild card. So in that sense, however, it was always open to the possible achievement of their objective because Congress can change its mind or amend what it has hitherto done. Indeed, the legislation in question was an amendment. So it seems to me odd to say that the investors were not considering an open future, because they were. They were an open future, both regulatory to having to do with the deregulation of airlines generally, but also an open future in that what Congress does, it can improve, change, or repeal.
So George and Elizabeth, if I understand Peter's argument, and it does make a kind of sense to me, these investors made a bet. They bet that some future legislation would make them economically better off. And that bet was wrong, because although the future legislation did make some people better off, it expressly excluded them from being better off. So why isn't it correct that that's not a regulatory taking?
Well, the one thing that's been left out of this by Peter, I think, is the role of the city of Dallas. And it's really hard to believe. And maybe the argument is that Congress can somehow immunize the city of Dallas from what it did. But first of all, the city of Dallas was a competitor of the Love Field partners. The city of Dallas owned the main terminal, owned the whole Love Field, though it had leased the land to the Love Field partners, and then of course eliminated the value of the leases, which is a heck of a thing to do. But it was a competitor of the Love Field partners because it operated the main terminal at Love Field, which out of which Southwest operated, and saw over time, especially with the building of the Lemon Avenue terminal, that the Love Field partners were going to be a competitor of it. The other signatories to the five-party agreement were also competitors. Southwest operated out of the main terminal, and so it would be very happy to get rid of the Love Field partners. Of course, Dallas-Fort Worth, so the city of Fort Worth, the Dallas-Fort Worth Airport Authority, and American Airlines, which dominated and still dominates Dallas-Fort Worth Airport, were all also competitors of the Love Field partners. So these guys get together, and again, the perfidy is by the city of Dallas, and cut off.
You're making a very good argument that sounds an antitrust law, not an takings law.
Well, except it's a little complicated in antitrust law, and there were some antitrust cases filed where the court ruled that the involvement of the government and the limitations, which I think are probably undeserving. I don't know if you remember our classes on Nora Pennington, but
They're coming back to me now.
It's complicated, but it's again they render it's taking because these through this five-party agreement enacted into the WARA, they render the leases valueless, and they then demolish the terminal. Demolish it. You got a perfectly good terminal here. In fact, a better terminal than the main terminal at Love Field, and the city and now approved by the Federal Circuit simply demolishes it. I mean, it's just hard to imagine this in the real world.
Now, at the risk of drawing another distinction, your last point seemed to be a physical takings point rather than a regulatory takings point. And I have a hard time, it seems like most of the arguments are regulatory takings arguments, but is there a serious physical taking argument?
Yeah, I think there is. I think there is, yeah. Well, and, again, those of you who are not lawyers, I think have probably a better sense of this. Those of us that are lawyers can come up with theories of one type or another to justify this, but the city comes in and demolishes, enters an agreement with other competitors of the Love Field partners, and simply demolishes the terminal. Yeah, I think there's a physical takings issue here. Serious one.
Elizabeth?
Yeah, I was going to say back to the regulatory as well. I mean, look, the physical takings, Loretto and cases like that say, a physical taking can occur either by or at the behest or with the blessing of the government, right? So I think there's maybe an argument there. But on the regulatory point, I think, Adam, your question was, well, if their bet was wrong, why wasn't the Federal Circuit right? And I think there's tremendous daylight between, their bet being wrong and their property being valueless, right, before the adverse government action. And that's what troubles me. And I appreciate Peter's points about the Federal Circuit opinion, but as I recall, one of the things you were saying is they got to this very troubling and frankly, in my view, quite dangerous language about, if you're cash flow negative, you have no value. If that's the case on a given Tuesday, you're out of luck. By from the predicate that their entire value of their property up until the moment of the challenge legislation depended on the future bet. And I don't understand how that could be right. That doesn't have a grounding in zoning cases or 100 years of law that say you look forward. And then the thing that troubles me is I'm looking at the page of the opinion that has that predicate. And the way they got to that predicate, that the entire value was bound up with the bet or the forward looking, was kind of assuming the premise, and it was the point I mentioned about the actual offer. They said, well, plaintiffs tried to market their property, I'm quoting here, to other airlines but never received an actual offer. So by the time of the WARA enactment, no airline had used the Lemon terminal or paid any rent to plaintiffs for more than 5 years. That could be said of a lot of projects, investment projects that are performing perfectly as intended. It's the actual offer scenario on a house. The fact that I don't have an actual offer yet today on my house that has value doesn't make it valueless. So I think on the regulatory side, there's a real problem with this opinion and allowing it to stand as sort of the gravamen of where federal takings law is going to come or go for all of these people with these problems if this isn't addressed. And I don't think it's an easy answer to say the whole value is bound up with the future bet, because I don't see anything in this opinion that substantiates that legally or factually.
Peter?
Well, speaking of the physical taking, that's a very weak argument in this case and the demolition of the terminal, because at the time the terminal was demolished, it was owned by the city of Dallas. It had foreclosed on the lease, so it had complete fee simple ownership of it. And if it had value to them, they could have run it themselves as a terminal. But the deal they had made with Dallas-Fort Worth Airport was there would only be 20 gates. So it was more valuable to them to follow through on that and confirm that there'd only be 20 gates so that they could fly from Love Field to anywhere they wanted to go. Now, that may be a rotten deal, and it may be economically bad for society, but it doesn't involve a physical taking of the field. It was taken by the owner to implement their own interests.
So a couple questions, Peter. I guess they could have forever continued to pay rent on something that they knew that a federal statute had made them impossible for them to recoup any money from. So that's one option. That's not a very attractive option.
That's not a very attractive option, because then they would have, but if they had, they would have forced Dallas to exercise eminent domain, and they could have made the arguments about what the property was worth before Dallas took the property. Now, the problem was that it had never actually been valuable. The comments that Judge Dyke made, when I agree his language was, I think, too loose, was that it had never been profitable, that under the Wright Amendment, they simply could not get an airline to fly out of that terminal. And Judge Dyke noted the fact that between the time that they acquired the sublease and the passage of this amendment in 2006, the plaintiffs had suffered a net income loss of $13 million. The point being of saying it had no value was that it had no value unless the legislation passed to allow them to fly out of the terminal wherever they wanted to go. And that didn't happen. So the ability of the law to capture the economic realities here, I agree, is a bit rough, not perhaps as well done as the judge would have liked, but there was never a time when the terminal showed any value other than if they got favorable legislation from Congress.
But another point. So the five-party deal, as adopted by Congress, turned into legislation, said you got to reduce it to 20 gates. And I suppose you can make discretionary judgments about whether those gates are going to be at the main terminal or the second terminal. But the deal also says in so many words that the terminal needs to be destroyed. Am I misremembering that?
No, it does.
Yeah, no, it does.
That's a fairly odd provision, isn't it?
I think
Very
that's
odd provision.
Yeah, I think that's an odd provision. I assumed that was in there to limit the ability of Love Field to expand further to protect the Dallas-Fort Worth Airport.
Well, it also protected the main terminal, Dallas and the main terminal.
Well, I think it protected Dallas-Fort Worth Airport more because from the perspective of the city of Dallas, more traffic coming out of Love Field was entirely to their advantage, regardless of whether they're acting as the owner or acting as the landlord. But the 500-pound gorilla here is the Dallas-Fort Worth Airport, and they're the ones that wanted to limit what Love Field could do. That's why the Wright Amendment ever existed in the first place.
That's true, but again, a monopolist reduces output. That's how you get the monopoly price up. So that and I don't know, Elizabeth, you may know what the lease terms for Southwest, if they changed over time after the War Amendment, but they probably went up because if you don't have the Lemon Avenue terminal, you got less source of supply at Love Field. The lease terms are going to go up.
Right, and I think that's the issue. I mean, setting aside that not profitable has never been a test and doesn't make any sense is it a huge problem. Let's talk about let's take this from a different angle. Let's say it did depend on the forward-looking bet. The other thing that's very troubling about this case, right, is the United States is the only party. The Federal Circuit says, okay, right or wrong, let's just take the premise that all of the value here depended on the forward-looking bet. When you look at the legislation, the bet that the petitioners had that these long-haul flight restrictions would get lifted actually did pan out. The only reason they were told you don't get any relief here is because the U.S. government, Congress, bundled that with the adverse parts of the statute, right? So this is a weird, I think the petition refers to it as laundering. But this is a very troubling thing because even if you want to take the Federal Circuit's premise that, and I don't think it's right, and I think the way they wrote it is a disaster, but even if you say, okay, look, this is partly about the forward-looking bet, when you read this opinion, it says you don't get the benefit of your bet, not because it was wholly wrong. In fact, it was right. You know, to your point, everybody's making money and flying out of this thing, and Delta, the JetBlue Brief cites the statistics. They were right. It's just that Congress bundled it. Congress, the U.S. government, bundled it with an adverse provision. And then the Federal Circuit took that and ran with it to immunize the United States government's action. It has a section on the special projects rule. We haven't talked about that. But, the Federal Circuit goes on to say, okay, it's all about the forward-looking bet. I think that's wrong, but fine. Then it says the forward-looking bet didn't play out. Well, that's not true. It did in part. And then it says, but you can't get any relief because it was bundled with this part that's bad for you, and then all of these old cases on the special projects rule say you can't get into the very action you're challenging to get takings value. Well, that's not even true. Those cases say you don't get incremental value that results from the challenged government action. It doesn't speak to the initial question as whether there's value in the first place. And the bigger point is, do we want a template like this that says anytime a government wants to get immunity for its actions, when it steps in and of its own accord wants to sanction something like this, an invasion of property rights, that this is how you do it? I think that's very troubling.
Well, it occurs to me to ask, what's JetBlue's interest in all of this?
As stated in the brief, JetBlue has an interest, generally speaking. It was, by the way, discussing space at the Lemon Avenue terminal, so it had an interest historically in this case. But the amicus brief says point blank, you have to consider the implications of the Federal Circuit opinion, and specifically a decline of Supreme Court review for the airline industry, and the stats are really staggering. JetBlue is the only post-1978 deregulation airline that's still operating as a standalone carrier. It's been very successful, no bankruptcies, no mergers, but it makes the point, not only in the brief, but in its public security filings, and its sophisticated investors agree that when they enter these markets, it is a long ramp. It could be years before they're cash flow positive, okay? So the idea that they should go into JFK and invest, and then it could be on day 99 of 100 where it's going to become useful, that the government can wipe it out with no compensation is crazy. And the other point they make, which is really critical on a competition standpoint, is when you look at where, if you allow these investments to play out, these long-term investments, fares have gone down, routes have improved, passenger choice has improved. So going back to George's opening point that all of this is actually part and parcel of social benefit, it's right there in the numbers, undeniable, and there's nothing in the Federal Circuit opinion that disputes that.
So let's shortly turn to your questions. There are microphones on both sides, and please use them, gather your thoughts. Assuming that the court agrees to hear the case, and even such an interesting and important case has a long shot, the court takes about 1 out of every 100 cert petitions. What do we think the current court will do? Where is the court on regulatory takings law? Anyone?
Ashley, you're the best person to answer that.
I've exhausted what I know about this
Well,
subject.
I can say something about that. I mean, I think that what we've seen in the Roberts Court has been a real interest in per se rules and takings, physical takings, as in the Horn case. There's not been a lot of interest in the sort of traditional regulatory takings cases. The fact that they didn't take the Maui case, they didn't take, I don't know exactly why that is, but they have not shown a great deal of appetite for it. Part of it is that when you have a test for regulatory takings, I mean, they tend to be, so the facts here are complicated. If you find a regulatory takings here, replicating it in another case is going to be very difficult. There are many factors involved, and the litigation aspects of that are also very difficult. So it may be they feel like there's not particularly fertile ground there for seating.
Actually, Elizabeth, I think that's a point that maybe argues against cert worthiness, that these facts are so weird that it's hard to imagine the court will announce a general principle based on them.
Well, I think that's the thing, right? I think certainly, and to Peter's point, I think the court is concerned, obviously, with not doing just error correction. That's in any way backward looking. They're very judicious about, the cert criteria, so I think that is a complication. I don't think it's a complication for this case any more than it is for the entire category of regulatory takings cases, because they're inherently fact-bound. And that's what I meant at the outset when I said I hope that the court doesn't make the perfect the enemy of the good, right? In any of these cases that comes up, you're going to have some hair around the record or some fact-bound aspect of it or some difficulty. So, if the test is going to be we need a perfectly clean vehicle and something that's going to recur, what I think actually gets it out of this box here, if anything does, is the fact that the way the Federal Circuit wrote it, this is the stop under the Tucker Act, right, in these precedents, this is going to be the law of the land. It's not written in a way that is, if there's a limiting principle, it's not apparent to me. So, and it's not rooted in the court's precedent. So I think you've got a conflict with what the Supreme Court itself has done. I think you've got tremendous practical and economic consequences that make it, an issue of greater importance than just these facts. And it could be applied in other ones.
And then,
So
of
one
course,
thing
there's
I would-
the Federal Circuit's presumption of reversibility. Yes.
One point to make is that in the big cases that Supreme Court has done in regulatory takings, typically the property owner is some lonely individual who has sort of stood out against some sort of oppressive government activity or perceived as such. And here you have very sophisticated investors who are able to hedge their investments. And I just think that generates less sort of below-the-head reaction on the part of the court.
Yes, sir.
Hi, Isaiah Kalanos here in Washington, D.C. We've kind of focused on the equities of Dallas and their role in it, but this is at the Court of Federal Claims and then the Federal Circuit, so it's looking more at the congressional action, it seems like, as a regulatory taking. That's really regulation, as you mentioned, the Wright Amendment, that's pushing the envelope here. So you did talk about it more briefly, but I'm wondering if there's more we can say about that aspect of it, because otherwise the Dallas aspect seems like a landlord-tenant, because in that, the Dallas is acting more as a private party contracting, as opposed to this Congress, which is actually acting as sovereign and making it more of a public law issue as opposed to a private law issue. So I'm wondering if there's more you can say on, I apologize having not read the full decision on this, but if you could speak to the congressional aspect of it. Thank you.
Well, I think your question picks up on a bit the point we were talking about before, which is the United States is the only party to the appeal in the Supreme Court, and I think the focus is rightly on whether that 2006 legislation affected a compensable taking. And there are obviously the two lines of authority, right, regulatory and physical. But on the regulatory, I mean, that's the way this works, right? I mean, it's the invasion of a private property interest that is caused by the federal action. And I think that test is met here. And the only reason it went off the rails is because the Federal Circuit departed from some very old precedents that made some sense.
University. This question is primarily for Peter Byrne. Do I welcome any insight from anybody else? And if I understand your argument correctly, and I maybe if I get it wrong, just correct me on that. Your point is that they knew that there was this restriction when they made the investment. It was pre-existing, and therefore it's not the same thing as when the government upsets an existing property right. But in the Palazzolo case in 2000, the Supreme Court said that the fact that a regulation that restricts your property rights pre-exists your acquiring them doesn't by itself mean that it can't be a regulatory taking. To the extent that that happened here, well, I think your argument is definitely better than the one that the Federal Circuit opinion makes. I do wonder, how would this be different from something like the Palazzolo case? Maybe there's some other reason why there's not a regulatory taking here, or maybe it's not enough of an infringement on property rights, something like that. But it seems like Palazzolo closes off the argument that if you acquired the right with knowledge of whatever regulation prevents you from using the property effectively, that doesn't by itself foreclose your claim.
Thank you, Ilya. So the Palazzolo case involved a case where there was an acquisition of property by the dissolution of a corporation flowing to an individual. And there was a regulation that existed that limited the ability to build in a wetland. And the court said that there was no per se rule against bringing a regulatory takings action simply because you acquired the property after the regulation went into effect. But what the court said is that it actually depends on the circumstances. It depends on, because in that case there was an automatic action of law. But I do think in this case, I didn't stress this, but I think the fact that the investors who are told are extremely knowledgeable investors, extremely sophisticated, bought into an opportunity that was entirely dependent upon getting favorable congressional action to relieve them from limitations, creates a very different case than existed in Palazzolo. Judge Dyke here tries to distinguish between new regulations that surprise investors and the elimination of regulations that they buy into knowing that they exist and hope they'll go away. And I think that's a valid distinction. I think it's more than what goes well beyond what the court decided in Palazzolo.
Several times there have been several comments or characterizations of this investment by the Love Field partners as a bet. They made a bet that the law would change. Well, the law was really pretty clear. There was a lot of opposition to the Wright Amendment, and that the Wright Amendment would have to go. And indeed, in the Wright Amendment Reform Act, WARA, it provided for the elimination of the Wright Amendment in 8 years. So this wasn't someone putting a quarter into a slot machine. You've emphasized that they're not very sympathetic because they're savvy, because they're smart, and were smart for a while. This was coming and did come, and the question is what was the mechanism by which the next step was taken, and that's why I think the perfidious role of Dallas is important in this. Because they sought a gain from getting rid of the Love Field partners and concentrating the gates in the main terminal, despite the superiority of the Lemon Avenue terminal, which they succeeded in doing. They bulldozed it.
Yes, sir.
Andrew Ward at the Institute for Justice. I'm part of the friendly crowd, so I suppose this is a hostile question for Peter. But what's always bothered me in my gut is the bundling that Elizabeth brought up. I mean, if this had been two pieces of legislation passed 1 second apart, there's a throwaway line about this in the merit cert petition, but it's always what got to me. If they repealed the Wright Amendment, the bet succeeds. The terminal is worth $133 million. And then a second later, they take it away. It's a taking. How could it possibly be that all of this turns on that 1 second and that it's one piece of legislation instead of two?
Well, Congress would have pretty bad lawyers to do that, wouldn't they? But here, I think the serious answer, and I think, is that this was a deal that was designed to primarily protect Dallas-Fort Worth Airport, but allow Love Field to flourish more than it had. And so the limitation on the number of gates was, in fact, an integral part of the lifting of the limitations on Love Field. In other words, that they wouldn't have done one without the other because Dallas-Fort Worth Airport would never have agreed to that. Now, you know, does that deal stink? Well, yeah, I mean, I totally, and I don't mean to suggest in any way in saying that the investors made a bet that they did anything wrong. I think they acted like, you know, smart business people. They just didn't succeed at it. And in part because whatever happened behind the veil in the five-party agreement, you know,
Yeah,
maybe it stunk.
The one point to add to that, though, right, is the deal was one thing, but it's the federal government blessing it, bringing to bear the power of the United States to say we're going to bless this, we're going to insert ourselves, and we're going to be the power that affects this reallocation and invasion of a property right, one against the other. Now, can they do it? Sure. If they didn't do it, then that antitrust case wouldn't have gotten thrown out as immunized by a government blessing, but it was. And so now to say the government's off the hook, at least, you know, doesn't make much sense.
Yeah, arguably that's a violation of the Due Process Clause. That this is a matter of making law in a way that falls below the basic standards of what you expect in a rule of law situation. But that's not what's being claimed here. What's being claimed is a taking.
Yes.
T.L. Covage from Washington. In the context of international investment arbitration, which can be analogous to takings litigation in the U.S., there's a concept called creeping expropriation, where the sovereign does a series of governmental acts to chip away at the viability of a business, to undermine its revenues, and then finally, when the sovereign administers the coup de grace, says, oh, well, this was a valueless enterprise in any event. Would you comment, any of you, on the risk that Judge Dyke's reasoning invites that kind of cynical behavior by sovereigns within our legal system?
Well, I think the way the opinion's written does pose that risk. I mean, it's, you know, sitting here today, we can't say where and when it'll be realized necessarily, but I do think that, as we discussed before, the opinion outlines a template for avoiding responsibility for a government-sanctioned invasion of a property right. The Constitution doesn't contemplate that that comes for free. The Constitution contemplates that when policymakers and people in government bring their power to bear and they affect or invade personal property rights, they have to pay something for it. It's not that they can't do or they can't act. It's that there comes at a cost. And the reason, the calculus there is we want policymakers to have to account for the cost of these actions, and that makes for good consideration of whether they're going to exercise their power in the first place. And if you upset that balance, which I think the opinion does, you know, it certainly could encourage people to come and look for this type of sanction, whether lawmakers will take them up on it or not. And then wholly apart from that, there's just things in this opinion about how you value the property right in the first place that really merit review.
Can I add just one thing? You know, Peter, you emphasize very much the fact that Dallas demolished the terminal pursuant to an eviction. I think that's a legal technicality. And I think it's really quite similar to the point you're making about creeping takings. I mean, of course, it's not strictly a legal technicality, but in thinking through the issues of this case, the fact that it was done by eviction after the Love Field partners quit paying is a pretty small part of the whole process.
That's how they got control of it.
No, I know. But again, I view that as a I view that as a lawyer's trick, basically. And again, those of you who are not lawyers, I think have a better sense of that than those of us who are lawyers.
Yes.
Well, I am a lawyer, but I'm going to try to put my hat on of thinking about it not like a lawyer. I'm more sympathetic to Mr. Byrne in the sense that, question for George Priest, the more you say, what bothers me is the role of the city of Dallas, the more I want to step back and say, okay, as a hypothetical, suppose the city of Dallas were not involved. Suppose this was just a straight speculation between a third party leasing land near the airport and building a terminal on the bet, again, that a certain path of regulation was going to be taken. And when it wasn't taken, the leases, in effect, did become valueless. The leases are now at a level at which they cannot reasonably have value, as shown by the fact that they were abandoned. And I would have to say that, we see so much speculation on the basis of the choosing to guess what the government is going to do. Is the railroad going to be built on this side of town, or is the railroad going to be built on the other side of town? You can even have leases that have option clauses built into them that the leases will terminate if a certain decision is made by the government opposed to the expectation of the person who take it. We don't want to have the government have to compensate individuals for their own well-meaning but loss of economic value. To me, that is more in the interest, that preserves the integrity of property rights rather than cutting against them. I do understand the point you're making about the city of Dallas, but I think that really does resonate in something to do with contracts or antitrust or some other part of the law.
Well, the problem is the city of Dallas was complicit in all of this. And someone made a crack about, I think it was you, Elizabeth, about the government not, if something else had happened, the government wouldn't have had good lawyers. The government's position here is, I think, pretty much responsible. They delegated to the city of Dallas to work out with Fort Worth to deal with this issue between Dallas-Fort Worth and Love Field. And then Dallas brought in private parties, competitors of the Love Field partners, Southwest and American Airlines. That's a bad thing. The government, and when the government later blessed that through the Right Act Reform Amendment, the U.S. government did have bad lawyers. Where was the FTC? Where was the Justice Department? In saying this isn't right. These competitors are forcing out this, and you talk about making investments and you have to make a judgment and so forth. Yes, but this is perfidy, as I say. That Dallas eliminated, almost breached, but through the five-party agreement, eliminated the value of the leases, and then invoked this eviction statute and eviction process to demolish the terminal. I think the city of Dallas is deeply complicit in this. And the problem is the federal government didn't catch it, really. It really didn't catch the consequences of this. And so, therefore, I think it constitutes a taking. They have to pay. And we really don't want the language of Judge Dyke in the Federal Circuit to define takings law, regulatory or physical takings law, for the future. And so that's why the Supreme Court ought to step in. But as Adam points out, they don't step in too often.
Well, and this would be one, I was going to say bad facts can make bad law, but I don't even see the bad facts here. And just one more point in response to your question. I don't think the petitioners or even the other cases would say that the government should pay just compensation for pure speculation. You know, none of the cases say that. The cases that are coming in on the other side of the Federal Circuit say it's got to be a reasonable investment-backed expectation, and it's got to be reasonably probable. It's got to be grounded in the record, which it certainly was in the Court of Claims record here. So I don't think there's a danger that if this were reversed, that they would be endorsing, you know, oh, you've got to pay for speculation. It's just a situation where the government chose to put its hands on something that invaded a property right. It should be judged under the right test.
So this has been a really good, robust discussion. Any concluding thoughts on the panel? Apparently not. Please, no, I take it back. Here comes one.
I could talk for a while. I was just going to say, I mean,
Probably have some other conclusions.
part of our concern here is, one concern is whether Judge Dyke's language will have a life after this and be taken out of context. I think that Mr. Will was taking Barack Obama's statements out of context, and the reality is, I don't know if I'm probably too old to count as a progressive, but I really don't think private property is at risk in America, folks. It's been here for a long time. We're Americans. We all love private property. And a lot of the anxieties that fuel regulatory takings litigation, I think, are misplaced.
Out of context. I'll tell you a story. In 1980, when Ronald Reagan was preparing for his one debate with Jimmy Carter, the worry among the Reagan advisors was that Mr. Carter would unearth some of the, shall we say, colorful things the governor of California had said over the years. For example, they said, when the Symbionese Liberation Army kidnapped Patty Hearst, they demanded that there be a free distribution of canned goods in downtown San Francisco. And the governor at that time quipped, this would be a great time for an epidemic of botulism. So, said his aide, what do we say if Carter brings that up? And there's a long pause, and an aide said, say it was taken out of context. I think Mr. Obama was really clear about what he meant, and that no one is saying that private property is to disappear, but I think this case and many others indicate how by degrees and small steps it can become attenuated.
All right, I think that was the concluding thought. Please join me in thanking this terrific panel. You know, Tim Dyke was also a professor of mine. Yeah, I know. I took communications law. He's in Wilmer College.
You know, essentially the same. Well, first, Obama's remarks couldn't be taken out of context. There were the but your assessment of where the progressive